Welcome to today's webinar, 2020, the Year in Review, Human Rights, the first webinar in our 2020, the Year in Review four-part series. My name is David Wong. I'm a partner in Fasken's Vancouver office, the co-leader of the National Labor, Employment and Human Rights Practice Group, and the leader of the National Human Rights Practice. I'm joined today by my fellow Labor, Employment, Human Rights colleagues, Rhonda Grintuch, partner in our Montreal office, Sarah Graves, partner in our Toronto office, and Nicole Singh, associate in our Toronto office. Before we begin, I have a few housekeeping notes. At the end of the webinar, please click the survey link underneath the video to fill in our survey. These surveys help us to determine future topics, and your input is greatly appreciated. During the webinar, if you have a question, please type your question into the chat box beside the video. At the end of our presentation, time permitting, we'll get to as many questions as we can. If you require technical support, please click the Tech FAQs or Tech Support Chat, which is located in the question chat box. If you're looking for COVID-19 specific information, we have a wealth of information in our COVID-19 Knowledge Center, which can be found at fasken.com. And last but not least, the next webinar in our 2020, the Year in Review series, 2020, the Year in Review, the Federal Sector, is being held on November 16th. Later in the month, on November 23rd, we're hosting 2020, the Year in Review, Employment Litigation, and our final webinar on November 30th, 2020, the Year in Review, Labor Relations. Please visit Fasken Institute on fasken.com for more information and to register. With that, I'm now going to talk on my presentation, Racism and Systemic Discrimination, Important Considerations for Organizations. Next slide, please. In 2020, there has been a societal awakening to the issues of racism and systemic discrimination. While the focus has been on policing, the impact has been far broader. Many organizations have taken steps to try and address racism and systemic discrimination within their organizations. In this presentation, I'm going to highlight some considerations for organizations relating to these issues. Next slide, please. Next slide. So to start, I'm going to talk about racism a couple cases from the BC Human Rights Tribunal. And they do arise out of BC, but I will suggest that they have applicability across the country in terms of the approach that adjudicators are going to take to these issues as they've evolved. The first decision is Francis and BC Ministry of Justice, and it's a 2019 decision of the chair of the BC Human Rights Tribunal. In this case, a Black employee, a correctional officer, filed a human rights complaint alleging racism at work. I'm not going to talk about the facts of this case, but instead just discuss the approach that the chair of the Human Rights Tribunal explained that they would take to cases of racism and in specific how proof of racism was going to be assessed. So to start with, the chair of the tribunal explained that intention when it comes to racism is not necessary. Instead, the issue, and proof of direct discrimination, direct racism as well, is not necessary. Instead, an inference can be drawn by the tribunal when looking at these sorts of cases. So circumstantial evidence may be enough, but there does need to be objective evidence. The tribunal explained that the perspective from which it will consider the inference and whether or not there is racism is not just the complainant's subjective point of view, not whether they believe they've been discriminated against, but instead the perspective of a reasonably objective observer. Next slide, please. The tribunal chair noted that it's difficult when you're looking at these kind of cases. There is no bright line when you're trying to draw an inference and consider whether in fact there's been racism. Now, sometimes there's the proverbial smoking gun. If somebody has made racial slurs, or it's obvious that their conduct is related to race, then those can be easy cases. But most of the time, those don't exist. And so instead, these inferences need to be drawn. And again, there's no bright line for looking at them. The tribunal chair explained that a contextual assessment needs to take place in these types of cases, and noted that the historical disadvantage experienced by groups is part of that contextual assessment. When it comes to what may constitute racism and a finding of discrimination, the tribunal chair went through a number of different examples, stereotyping being one, and noting that often when stereotypes are applied, it's subconscious. The tribunal chair noted everyday racism, which I think are so often referred to as microaggressions, and how these can be little actions on a regular basis that you may not seem that significant, but can have a really significant impact on the individual suffering from them. Similarly, individual incidents, while sometimes they can be ambiguous or explained away, when considered in context and with a larger picture, those can be discriminatory, can be racist, and the tribunal needs to be aware of these as they're assessing these types of cases. Finally, the tribunal chair explained that racism is often unconsciously applied and unrecognized even by those practicing it. So that lack of consciousness of even being racist is obviously something that's extremely challenging when it comes to addressing racism within organizations. Next slide, please. So with that context, I'm now going to talk about another decision, Campbell and the Vancouver Police Board. And this was a decision of the BC Human Rights Tribunal that followed the Francis decision. It does relate to policing, but I would suggest that the analysis and the approach taken by the tribunal is a warning for all organizations, and something for organizations to be aware of that goes far beyond policing. In this case, it was a complaint filed by an Indigenous mother against the police. And what happened? She was out walking late one night, walking her dog, and she looked across the street and she saw her son with a friend walking and gave her son a wave. And shortly after that, a police car pulled up, and an officer stepped out of the police car and arrested her son and her friend, and his friend. And the mother came across, was obviously concerned about this happening, didn't know what was happening, and started asking questions of the police. The son and the friend were also quite agitated by obviously being placed under arrest like this. And the officer was alone. And so with tensions high and feeling outnumbered, the officer called in for backup. Now the mother was distressed by the fact that backup was being called, given that in her view there was no resisting arrest, everyone was cooperating. When the other two officers arrived, one of them was asked to take the mother to the side. So he did, took her some distance away from the arrest so she couldn't observe the arrest of her son anymore. The officer also got in the way, blocking her view, and wouldn't answer her questions about the arrest. Eventually, the son was taken in and released about 3 hours later, as there was no basis to hold him. The entire interaction for the mother lasted about 20 minutes. The tribunal noted in this case, there were no comments made by the police relating to race, color, or ancestry. So there was nothing said in this interaction, no racial slurs or no comments even relating to race, color, or ancestry. Next slide, please. The issue then was whether through the actions of its officers, the Vancouver Police Board discriminated against the mother on the basis of her race, color, and ancestry. Next slide, please. The test for prima facie discrimination. So the tribunal explained it's the same test. So despite what the chair had explained in Francis about the approach to proof, the test for prima facie discrimination remains the same. And this is a test that's been well accepted by the Supreme Court of Canada many times. Is the individual a member of the protected group? Have they suffered adverse treatment? And is there a nexus between the membership in that protected group and the adverse treatment? So question here, the substantive issue was the nexus question, whether the complainant's indigeneity was a factor in how the police treated her. Notably, when it came to how the tribunal framed this question, it didn't ask it in the way that is often asked when we're looking at the three-part test and the nexus question. It didn't ask, was the complainant's indigeneity a factor in the police conduct? That would be sort of what I would call the typical framing when it comes to the prima facie test. Instead, the tribunal asked it in this way: did the police conduct have the effect of perpetuating the historical disadvantages endured by Indigenous people? And the framing of that question, of the nexus question, I think is very significant, because again, it's a shift from looking at it from the perspective of, was their conduct discriminatory? Did they do something themselves with intent to discriminate? Could it be looked at that way? And instead really shifting it to a question of systemic discrimination. Was their conduct, did their conduct have the effect of perpetuating that disadvantage endured by Indigenous people? So the systemic discrimination that exists out there. And then the tribunal said, if so, the complainant's indigenous identity was a factor in the adverse treatment. So therefore the nexus would be established. Next slide, please. The tribunal member followed Francis and explained that no intention was necessary and that an inference of discrimination would be sufficient, but did explain that no presumption of discrimination was going to be made. So the tribunal explained they're not going in with a presumption just because of context that there was discrimination. There does still need to be objective evidence, and they will look at it from that perspective. Next slide, please. So the question for the tribunal again was an inference of discrimination more likely than the Vancouver Police Board's explanation of the officer's conduct? And here again, the tribunal, following Francis, explained that the broader social context was important. Next slide, please. So the social context that framed this interaction was, according to the tribunal, the tribunal needed to take into account the past and present effects of colonialism and historical trauma on Indigenous people without requiring the individual in each case to prove these events and effects. So the context here was the colonialism and historical trauma being recognized by the tribunal without needing any proof of that for Indigenous people. So with that framing, the Indigenous people, the tribunal recognized Indigenous people continue to have a troubled relationship with all aspects of the Canadian criminal justice system, including the police. So obviously that context becomes extremely important when you frame the question of, did the police conduct have the effect of perpetuating historical disadvantages endured by Indigenous people? Those historical disadvantages, well, what are they? And the tribunals accepted what they are without having that to be proved. Next slide, please. So in this particular case, the tribunal found that the police conduct did have the effect of perpetuating historical disadvantage. Here, there was a lack of training and awareness on the part of the officers. The tribunal found that there was a misunderstanding of the complainant and treating her conduct, and the police treated her conduct as suspicious. The evidence of the constable who had taken the mother away was that the mother had been erratic, uncooperative, and a verbally hostile woman. And the tribunal said this was a serious misinterpretation of her behavior that night. Tribunal said she was single-mindedly focused on the arrest of her son and finding out as much as she could about what was going on, and was not erratic but scared when considered in that context. Ultimately, the tribunal explained that the police officer's reaction was not proportionate. Next slide, please. So despite the fact that there was no intention, no conscious discrimination, the tribunal inferred discrimination in this case and found for the complainant. Next slide, please. So the complaint was justified. And the remedies that the tribunal awarded here, they ordered the Vancouver Police Board to provide specific anti-racism training to its officers and $20,000 injury to dignity damages. So a 20-minute interaction in these circumstances resulted in $20,000 plus the organization being required to institute this anti-racism training. And again, remember, this is in the context of no racial slurs, no comments about race, nothing to that effect. But the tribunal finding this is systemic discrimination and there's a problem here and these are the remedies. So some important lessons for organizations, some risks that exist out there as it relates to these types of complaints. And you can't simply rely on the fact that individuals within your organizations may not intend to discriminate or may not say something racist. That's not going to be good enough. Next slide, please. So what should organizations do? I'm going to talk a little bit about some of the defensive strategies that should be put in place, recognizing the risk that exists out there. And then I'm going to talk a little bit about some of the things that already exist out there, specifically equity, diversity, and inclusion initiatives that a lot of organizations have in place, and the hidden risks that exist there that organizations, I think, are not necessarily thinking about. Next slide, please. Next slide. So on the defensive side, anti-racism and systemic discrimination awareness campaign. This is critical because, again, recognizing that intention doesn't matter, and that a racial slur, racist comments, those sorts of things are not going to be necessary for there to be a finding of racism and a finding of discrimination and remedies ordered against individuals and organizations for this type of behavior. Awareness becomes very, very important. It's going to be critical for organizations to ensure that those within their organizations understand systemic discrimination as best they can, understand that there are these things, there are microaggressions, there are other things that can take place which are discrimination, but that they may not think, they may not realize are discrimination. Same with stereotypes, all of that. So the training becomes significant. The awareness is going to be critical. That's going to be critical both for avoiding conduct by individuals that may lead to human rights complaints, as well as for defenses for organizations. If those steps aren't taken, it takes away a defense that the organization has as to what they should have done to prevent this from happening. Of course, with that training, often policies are going to be important to show what the organization expects of its employees and to lay that out. But I'll just touch very briefly on policies with the next slide, please. So this is a decision, Lewis and WestJet Airlines. It's a decision that some of you may have heard me speak on before. I'm not going to get into the facts, but just touch on it briefly for the purposes of this discussion as it relates to policies. In this case, an ex-employee had filed a class action lawsuit alleging breach of contract by WestJet for failing to live up to what the ex-employee called its anti-harassment promise. And so what WestJet had were policies, anti-discrimination, anti-harassment policies in place, and the employee took the position that WestJet had not met its obligations under those policies or its commitments under those policies, and therefore, you know, it was bringing a class action on behalf of all employees for this breach of contract. The court didn't decide whether or not there was in fact a breach, but was looking at the question of jurisdiction here, but did say that, yes, this could be brought as a class action. It could be a breach of contract because WestJet would rely on these policies to discipline and to terminate employees in certain circumstances. So in that way, WestJet can't have it both ways. If it's going to do that, then it can be held as well to the promises that are made in those policies, and those can be breach of contracts if they're not lived up to. Next slide, please. So when it comes to these policies, and this is sometimes a challenge as it relates to policies, and certainly as it relates to issues like racism and systemic discrimination, organizations, when putting together these policies, will often have lofty goals and want to say all sorts of things about what they're going to do and how they want to sort of live these kind of issues and what response they want to take. But if you don't live up to them, as that WestJet case shows, they can be used against you. So while you may want to say some things in those policies, it's important to make sure that you don't go beyond what you can actually live up to. So the policies should ensure that they're sufficient, meet goals of awareness, certainly state expectations and obligations on employees, but avoid the overly broad promises and commitments that are often in these types of policies. As well, it's obviously extremely important that organizations ensure that the training that they say is going to take place does take place, and same with the promises and commitments in those policies. Next slide, please. So next, just going to touch very briefly in the short time I have left on proactive strategies. We say proactive strategies, it's more what organizations are currently doing and some things to think about. Next slide, please. So as mentioned before, equity, diversity, and inclusion initiatives. There's right now, I'll call it a bit of a buzzword as it relates to EDI and organizations taking steps in response to the societal awakening on racism and systemic discrimination to try and increase, to take to initiatives to increase diversity and those sorts of things, which is great. But one of the things I think organizations aren't recognizing when they're doing that is the risks that does exist in doing so. Specifically, when you put in place a diversity, say, hiring initiative, by its very definition, there is prima facie discrimination. You're going to be discriminating against certain groups for those who fit within the diversity that you're trying to increase. That is inevitable. That is what is a diversity initiative. Now, what comes with that is the risk of a human rights complaint. Under the legislation across the country, there's protection, there's defenses provided for, special programs. Next slide, please. And you see on this table, each jurisdiction in Canada does have protection for these special programs, these EDI type programs. But you see on the right hand column there, yes or no for the pre-approval. So some of the legislation in some jurisdictions, you can get pre-approval for those special programs. Others you can't, you have to wait, and they can be used as a defense after the fact. Some, in fact, you can do both. You have the option of going in advance or waiting till after. Next slide, please. The risks, though, if you have the opportunity to get that pre-approval, I would strongly recommend doing so. While there is some cost associated with doing so up front, it ensures that you are protected, that your program has been approved and properly designed and fits within the legislative defense. If you don't, there is always a risk that you may have missed something, or you may have not brought your program under the language of the legislation to provide that defense. And if so, then you could be in trouble when it comes to a human rights complaint and having to defend yourself on that. Thank you very much for your attention and your time. With that, I'm going to now pass over the floor to Sarah Graves to talk about sexual harassment. Thank you.
Hi, everyone. As David said, my name's Sarah Graves. I'm a partner in the Toronto office, practicing labor, employment, and human rights laws. And I know we're all looking for the silver lining these days. So even though we all can't be together in person, there's almost 1,000 of you participating with us today. So we're just thrilled that you've all been able to join us. So we're going to spend the next 20 minutes or so talking about sexual harassment and some of the key developments and trends that we're seeing. Next slide, please. So we're going to talk about sexual harassment in the virtual workplace. And I know that many of you in HR, and certainly us in employment law, have a saying, which is, you can't make this stuff up. And you will see when we discuss some of these cases that that is very true in this circumstance. We're also going to talk about the continuing impact of the MeToo movement, especially when it comes to investigating sexual harassment complaints. And then we'll talk about a few interesting recent developments. Next slide, please. Next slide. So I thought we'd start off by looking at where we were before the pandemic. So these are the statistics from the Angus Reid Institute from 2018 for you to take a quick look at. Interesting slides were 52% of the Canadian women surveyed said that they had been subject to sexual harassment in the workplace. And the other thing that I thought was very interesting was, of those who reported the harassment, only 1 in 10 felt that they had received a satisfactory resolution. So that's the stats for where we were. So what have we been seeing this year? Next slide, please. So as we all know, many people are working from home these days. They're working in some section of their home, they're in their bedroom, some home office, they're working in their old sweats. And the question is, well, since we're seeing so many people working from home, have we seen a decrease in sexual harassment complaints or sexual harassment problems in the workplace? And the short answer is no. I mean, while we have been seeing over the last several years harassment cases involving technology, so things like Facebook and texts and various chats, we're seeing that continue. But now we're seeing cases or complaints involving the very technologies that people are using to remain connected during the pandemic. So, Zoom, Teams, WebEx, you name the medium, we're seeing some kind of issue. So I've collected on this slide a few examples from recent newspaper articles that talk about problems that we're seeing in the workplace through Zoom. My favorite's that very unsubtle one at the bottom: he wasn't wearing pants, cyberbullying, sexual harassment in the age of Zoom calls. Next slide, please. Many groups are talking about this serious issue during the pandemic, the Canadian Labour Congress being one of them. and talking about, well, what are the factors that are contributing to this? One is the increased isolation. So the thought is that maybe people are less connected to policies and expectations because of the casual home environment. And also they're less likely to report because they're working from home. Complainants in this particularly, poor economy are concerned about reprisal and the ability to find another job. And then we're also seeing some increased concern about domestic violence. In the last, even just a couple of weeks, I've been involved in or been aware of a few of these cases, specifically involving Zoom or WebEx. In one instance, an employee was making an inappropriate comment about the fact that a coworker had not turned on her camera during a Zoom call and was speculating in an inappropriate way about why that was happening. And in two other cases, there were employees who were clearly doing things they shouldn't have been doing during work meetings, but then they made the situation much worse by inadvertently sharing their screen. So one, to display an inappropriate discussion they were having about a female coworker, and in another example, to display the pornographic video that the person was watching while they were actually attending the Zoom meeting. Next slide, please. So what should employers do when it comes to dealing with this issue? I mean, the first thing is to make sure you have a work from home policy or a remote work policy that sets the expectations clearly, that emphasizes expectations regarding conduct, that the respect in the workplace policy still applies. Employees are expected to be professional while working from home. They're expected to dress appropriately for meetings, things like that. Think about how to maintain employee engagement and connection so you don't suffer from the issues that result from the isolation that may occur when people are working at home. And don't pull back on your training. It's very important to conduct the respect in the workplace training that you might usually do, but to make sure that people are aware of how those policies and how that training impacts the virtual workplace and how those expectations are still current in that environment. You also want to make sure that the employees know how to use the technology. In the last two cases that I mentioned a minute ago, the employees did not know how to appropriately use the technology and accidentally shared screens. So, the training wouldn't have made any difference to the fact that they were engaging in behavior they clearly shouldn't have been during the meetings, but at least others wouldn't have been exposed to it. So make sure the employees know how to use the technology. Next slide, please. Next slide, please. So let's look at the continuation of the hashtag MeToo movement and the continuing impact that we are seeing. So we're still seeing different waves of public sexual assault and harassment accusations that often start on social media. We're seeing a clear impact on investigations and adjudications of complaints and cases. Because of the attention that has been played in the media, we often see complainants who expect a very quick and decisive action, like being terminated, like a manager being terminated. That's not something that's realistic given the way investigations have to take place and that there are procedural issues. We're seeing companies investigating older complaints that they might not have investigated previously. We're also seeing an impact on the investigation of older complaints or the adjudication of complaints. So we're looking at courts applying what they're calling modern standards. In this case, this Calgary case, it was an appeal of a judicial review of a decision that upheld an arbitration that had overturned a termination for sexual assault, which involved the grabbing and squeezing of a female employee's breast. And the arbitrator had found that that touching had occurred without consent, but found that it was on the lower end of the spectrum of sexual harassment. They found that the complainant hadn't been significantly traumatized and basically just concluded that it was an impulsive, ill-thought-out decision. So in looking at this, the Court of Appeal talked about how important it is to realize how demeaning sexual harassment is, how sexual assault, which is this touching, was actually a very serious form of sexual harassment, and felt that the arbitrator had played down the significance of this particular incident. and made some interesting comments also on the issue of precedent. So the Court of Appeal talked about how the precedents that had been relied on by the arbitrator were actually ones that were incongruent, they said, with modern society's view of acceptable conduct in the workplace, and that relying on those types of precedents would actually make an award unreasonable. And then they commented about how there's just no place for unwanted sexual touching in the workplace. Next slide, please. Next slide, please. So here's a case out of the Ontario Tribunal that talked about guidance for investigations, this AB case. In this case, there was an invitation by a supervisor to an employee to come to their hotel room. There was alcohol involved. The complainant woke up in bed next to the particular respondent, and then there was an issue about him trying to prevent her from leaving. There was actually a criminal case where he had admitted the behavior, and at issue was the company's response. There was a report to HR, but the employee, the respondent, was still in the workplace for a period. There were no real suggestions about how to address the situation. They asked the employee if she'd accept an apology. They told her about EAP, but beyond that, they didn't do very much. And what was interesting is the court went through the criteria. There's about 10 criteria that was set out in a previous decision called the Laskowska decision about what they expect to see when you're addressing a complaint and what the investigation should look like. And this court went through those categories and applied them to this sexual harassment situation in the modern environment. So it's a very interesting decision that, I'd suggest you read if you're looking for a great example. One of the interesting comments was a situation where the original investigator said, it's a he said, she said situation. I can't really determine what happened here. And here the tribunal made a point of noting that the fact that she couldn't determine whose version was accurate was actually a result of her own poor investigation. So I thought that was a very interesting comment. Next slide, please. Here's a few other interesting recent cases that deal with investigation issues. So in this NK case, which involved a complaint by a direct care worker at a home for disabled adults against a supervisor, you had a situation where things started with romantic comments, personal comments, then there were some physical advances that were made, and other touching over a period of time. And the employee basically said that they had initially objected, but then acquiesced. And at one point testified that she had actually acted like she was in a relationship with the respondent. Here, the tribunal did a nice discussion about this idea of consent versus acquiescence. And they found that harassment and discrimination had occurred in that case and said that it should have been known that the actions were unwelcome, given the initial objections and the continuing displays of reticence. So I thought that was a very interesting decision. And it basically causes us as investigators, or when we're advising investigators, to think about issues like power dynamics between the parties, think about whether there have been any threats, either implicit or explicit. In the Proskauer case, again, in this employee case, there was really interesting discussions about whether comments rose to the level of sexual harassment or whether they were in poor taste. And it's an example of how the adjudicators, the courts, the tribunals are really looking at every individual comment that was made and trying to put it in a broader context. In the A.B. Singer case, which was a high water mark of damages at its initial tribunal level, there was a judicial review, and it involves the issue of findings of credibility, because there had been some gaps in the memory of the complainant. And in some instances, she was not able to provide a lot of detail. And in the same instance, the respondent had also had some inconsistencies in his testimony. And the appeal by the respondent was basically, the credibility should have been negatively affected of the complainant because of the gaps in memory and because she didn't have a lot of detail, because the inconsistencies in the respondent's testimony had counted against him. And the court basically upheld the original decision and said that those things, in the case of a trauma-informed approach, so gaps in memory and not a lot of detail, were not signs of falsification, but were actually the result of her situation. Next slide, please. So when we're looking at investigations, whether we're doing them or we're advising about them in this environment and in 2020, be careful of a few things. It shows the importance of training of your investigators, that those conducting investigations are doing so with the current thinking and not the way, for example, we may have interpreted consent 15 years ago. Think about language used. So, for example, we've seen cases overturned where adjudicators have referred to instances as pranks as opposed to assaults. Think about consent. As I said, it's changed over the last 15 years. Now we're looking at questions like, was the consent coerced? Consent to one part of a relationship doesn't mean consent to the rest of it. Things like failure to fight back, delay in reporting do not necessarily mean a lack of credibility or that the event didn't happen. Other things like any ideas you may have about what a complainant should behave like after a particular incident are also looked at now very carefully. And we need to be conscious about how many times we're asking a complainant, especially in an assault case, to repeat their story, because that's been a factor in increased damage awards in some cases. Next slide, please. So just a few additional developments I wanted to bring to your attention briefly. Next slide, please. So the data I started the presentation with was from the 2018 survey. There is currently a new survey that's being done by a group at Western, U of T, in connection with the Canadian Labour Congress. They're gathering data until April of 2021. It's designed to get information from both union and non-union employees and to try and determine broadly and more currently what the experience with workplace sexual harassment is in reporting. And they're going to pay particular attention to issues involving marginalized workers and precarious employment. And the goal is to allow this information to inform policymakers, government, and employers. Next slide, please. There is also, like in every area now, an app that deals with sexual harassment. This is this Bottler for Citizens app. It allows individuals to go on and enter facts about their particular situation and get information about sexual assault, get information about next steps and resources. It's been developed with some funding from the Department of Justice, and it uses a trauma-informed way of asking questions in a conversational tone where people can enter a lot of data and then they get information about next steps. The goal is, the founder says, to arm people with meaningful understandings of the issues and then some first resources so that they can then try and get remedial action where necessary. And again, this is part of the government's initiative to combat sexual harassment that was announced last year. We have, as you all know, some new workplace violence and harassment requirements that are coming into force for the federal sector. That is something that's going to be covered in our next section, so we'll just put that as a placeholder. And then lastly, we're continuing to see activity in class actions, like David had mentioned previously. Often these are coached in terms of negligence or breach of contract. We've seen a settlement in the RCMP case. There's been cases against the Canadian Armed Forces, police, WestJet, as David has said. We are several years behind the United States in terms of class actions in this area. It's been going on down there for 20 plus years. And while there are some procedural and other hurdles that are being faced, when people try to bring class actions here, it's still a risk for employees, and it's still something that's very interesting that we're going to be following the developments as this year continues. So thanks very much for your attention, and I will turn it over to Rhonda.
Thank you. Good afternoon, everybody. My name is Rhonda Grintuch. I'm a partner at the Montreal LEHR Fasken office. It's a pleasure to be with you this afternoon. So I'll just jump right into my portion of the this afternoon's conference, which is going to be to take a closer look at the quantum of damages and the trends that we're seeing in some awards over the last year or so. And in particular, we have a couple of record-breaking awards that I'd like to delve in a little deeper with you this afternoon. We could go to the next slide, please. Thank you. So the tribunals and the human rights commissions continue to recognize that, in general, the aim of human rights legislation is the removal of discrimination, and the approach is not intended to be punitive. It's not to punish the discriminator or the employer for that matter, but rather to provide relief for the victim of the discrimination or of the sexual harassment. The remedies are meant to be effective and consistent with the almost constitutional nature of the rights that are to be protected. Now, this concept continues to be true at the present day. However, what we're starting to see is that tribunals are using the discretionary component of the awards that they're granting to a much greater degree to compensate a person for the harm that has been suffered. And in particular, in the last 3 to 5 years, I would say, there's generally been an upward trend, particularly in the quantum of damages that are awarded for injury to dignity. So as a result, with keeping that sort of shift in mind, we should recognize that older cases, even though they might present similar facts that have come before commissions and tribunals, might not be in this day and age a good predictor of the awards that a human rights tribunal might grant to a complainant. Next slide, please. So there's 3 decisions that I'm going to be discussing this afternoon, one of which the NK decision was mentioned by my colleague Sarah. We could skip ahead, please, to the next slide. And the next slide, please. So the first case is the Escobar case. This is an interesting case involving discrimination and harassment based on ancestry, place of origin, sex, pregnancy, sexual harassment, sexual solicitation, and reprisal in employment. It was contrary to the Ontario Human Rights Code, and the allegations complained of really ran the whole spectrum of possible impugned conduct. Here, the applicant was a bank teller with a international bank here, and the respondent was a regular customer of hers, and eventually through discussions the respondent was led to make her a job offer. So he actually induced her to leave her position with the bank and to take up the offered position as his executive assistant with the company with which he was the CEO and president. So in this case, the applicant's period of employment was actually very short. It lasted from only May to August of 2017. And yet during that time, the respondent expected her to have lunch with him on a very regular, almost daily basis, drinks after work that lasted into the evening. He invaded her personal time. This eventually led to him making sexualized and stereotypical comments about her ethnicity. He gave her also unwanted massages in the workplace in front of other colleagues. He touched her leg during lunches. She, after all this conduct, felt judged by her colleagues due to his unwanted and unwelcome attention. He also made repeated comments about her ethnicity, her place of origin, her appearance, pregnancy, her purported association with Pablo Escobar. Eventually, she felt isolated, she felt embarrassed and humiliated in the place of work in front of all of her colleagues because of the unwanted attention that the respondent gave her. She felt she was treated as his personal property. He even pretended that there was a relationship going on between them. And then eventually, once the applicant brought her fiance to a work event, the respondent's attitude markedly changed towards her. He suddenly changed her role, and she attempted to raise her human rights to him as an objection, and was very quickly terminated. Next slide, please. So in this case, the tribunal found that the applicant had been sexually harassed on the basis of ancestry and her place of origin. We can go to the next slide, please. We'll look at the monetary compensation that was awarded. So the tribunal discussed the main factors that are to be evaluated when assessing the quantum of damages that should be awarded, specifically for the head of injury to dignity, feelings, and self-respect. So the two main facets of a case that a tribunal will look at least as far as the Ontario Human Rights Tribunal is concerned, is number one, the objective seriousness of the respondent's conduct, and secondly, the effect on the particular applicant who experienced the discrimination. So the first criterion recognizes that injury to dignity, to feelings, self-respect is generally more serious depending objectively on what occurred. The second criterion takes into account the applicant's particular individual subjective experience in response to the discrimination. So damages are going to tend to be at the higher end of the range when the applicant has experienced particular emotional difficulties as a result of the conduct suffered, and when his or her particular personal circumstances make the effects particularly serious. So the factors that have been identified in past cases, specifically by the Ontario Court of Appeal, and that are particularly relevant, are the immediate impact of the discrimination or the harassment on the complainant's emotional or physical health, as well as the ongoing impact of the discrimination or the harassment on the complainant's emotional or physical health. The complainant's particular vulnerability is also a big factor that plays into the tribunal's awards, whether the complainant made any objections to the offensive conduct. Another factor is the respondent's knowledge that the conduct was not only is not only unwelcome by the complainant, but viewed actually as harassment or discrimination contrary to the person's rights. The degree of anxiety that has been caused to the complainant is also a factor that is tends to be considered, as well as the frequency and the intensity of the impugned conduct. So a review of the awards that we're going to be looking at that are really at the higher end of the range show that physical misconduct, usually over a prolonged period of time, against very vulnerable applicants, are going to situate the award at really the very highest end of the spectrum. Another important factor is the particular vulnerability of the complainant, which could be in certain cases due to the complainant's immigration status, the complainant's age, or in certain cases a serious abuse of power by the respondent. So particularly in cases where the respondent acted as the complainant's direct superior and where he or she wielded a lot of power in the workplace against the complainant. Next slide, please. So the award in the Escobar case by the tribunal was $50,000, excuse me, as compensation for injury to dignity, to feelings, and to self-respect. This could be surprising given that the period of the conduct spanned only under three months, actually. She was employed for a very short period of time. But what the tribunal remarked on was the numerous comments in the workplace that were inappropriate, the physical touching of her shoulders and legs. Although it found that the touching she experienced was serious but not egregious. However, in this particular case, the tribunal felt that the applicant was particularly vulnerable, given that the perpetrator of the offensive conduct was her supervisor. In this case, it was a very small office. She didn't have anyone else really that she could make a complaint of harassment and discrimination to. And the tribunal found that the respondent did seriously abuse his power and took a reprisal against the complainant when he changed her role after her complaint that he was mistreating her. So the respondent's position as CEO and president of the company was ultimately a factor that was considered to have greatly enhanced the vulnerability of this particular applicant. Another interesting component of the decision was that the tribunal found that the personal respondent, so the perpetrator of the acts himself, was jointly and severally liable, along with the employer, for the restitution to the complainant of $50,000. The company was held liable on that basis because the respondents the respondent was considered to be a directing mind of the corporate respondent, and that was what led to the joint and several liability on behalf of the corporation. The tribunal also ordered that the personal respondent follow a Human Rights 101 training. We can go to the next slide, please. So these are some of the factors that were weighted heavily by the tribunal, and some of which we've discussed there. So despite the short period of time over which the events occurred, and the conduct of the respondent was considered to be particularly serious, and what was remarked upon was the authority, the level of authority that the respondent wielded over the complainant. Next slide, please. In the ANK decision that my colleague Sarah discussed earlier, this was a case that involved allegations of discrimination based on sex, sexual solicitation, sexual harassment, again under the Ontario Human Rights Code. So this this decision should be noted because it was the second highest damages award in Ontario to an employee based on the egregiousness of the sexual harassment and the solicitation she suffered, and the reprisal from the respondent, who in this case as well was her direct supervisor. So the applicant here was a direct care worker, as Sarah mentioned, at a group home for adults with disabilities. The respondent was her supervisor, and her employment here lasted a period of about 1 year, from January 2016 to December 2016. And what's interesting here is that the applicant's personal history played an important role in the tribunal's assessment of the facts of the case, and ultimately led to a very high award as compensation. We'll discuss sort of her personal history a little bit later on. We could go to the next slide, please. So what happened here was the impugned conduct, which really began almost immediately during the employee's probationary period. It included sexual harassment, physical and sexual assault, ultimately. The respondent here repeatedly mentioned to the applicant that he was in charge of assigning her shifts, and the applicant was eager to accept as many shifts as were available. So her behavior that followed all throughout, the months of her employment were framed by that position of authority over her scheduling that the respondent held. Eventually, the respondent began to call her, text her on her cell phone on non-work related matters. It progressed to requesting massages in the workplace, eventually an unwelcome kiss, sexual touching, ultimately sexual intercourse. Now, the applicant here testified that she and the respondent entered into what was a very strange and seemingly consensual relationship, but she even began to act as if they were in a relationship as a result of the respondent's conduct, but she was simply giving in and going along with the respondent's conduct. And what happened was they began to see each other outside of work. The applicant apparently repeatedly stated, the respondent repeatedly stated that he held power over her job security and her hours. Once the probationary period ended, the applicant tried to get away from the respondent, and she applied for a transfer to another group home, which was operated by the same organization. She eventually transferred, and yet the respondent continued to contact her and to even visit her in her new workplace. When the applicant told the respondent at her home that she wanted to end the relationship, he became angry. He physically and sexually assaulted her in her home. And then what happened was, strangely, the respondent pressed charges against her for having assaulted him at her home. This ultimately led the organization to conduct a workplace investigation of harassment, where they looked at both the applicant and the respondent's behavior. The organization ultimately found that both the applicant and the respondent engaged in inappropriate activity in the workplace, and they were actually both terminated from their positions. But because of the nature of the charges that were brought against the applicant, being assault, she wasn't able to find other employment in her field for almost a year that it took for her to get the charges reversed. If we could go to the next slide, please. So the tribunal here found that the respondent was sexually harassed, she was solicited, she was discriminated against on the basis of sex. The tribunal held that the respondent ought to have known that his actions towards her were unwelcome, given her objections that occurred in the beginning, and her displays of visible displays of discomfort, of reticence, even though eventually she acquiesced to the respondent. And as Sarah mentioned, there was a nice discussion on the notion of consent by the tribunal. This was examined in detail, and the tribunal arrived at the conclusion that the relationship was not in fact consensual. The adjudicator reasoned here that being bullied and mentally beaten down into a state of fearful compliance does not constitute true consent. And in short, consent under the law does not extend to situations where a party complies simply because they fear the consequences of refusing. If we could go to the next slide, please. We'll take a look at the compensation that was awarded to the complainant, which, as I mentioned, this is the second largest award for injury to dignity, feelings, and self-respect that has come out of Ontario. So the tribunal's decision, they ordered $170,000 as compensation for injury to dignity, to feelings, to self-respect. The tribunal gave particular importance to the fact that the respondent was a direct supervisor of the applicant, and he had sole responsibility for determining her weekly hours of work and for assigning the shifts to her. Now, what's interesting in this case is that the applicant had actually asked for damages in the amount of $100,000. So the tribunal's award obviously exceeded this amount by quite a lot, almost double. And this is one of the rare cases where the tribunal was led to grant an award that exceeded that which was requested by the applicant. Now, the tribunal recognized this very clearly and stated that the facts of this case were really so egregious that it warranted a higher award than what the applicant sought. Next slide, please. So here the applicant stated that the specific background, the tribunal stated that the applicant's specific background and life circumstances were a very important factor here. The applicant was in a highly vulnerable position. The reason why is that there were facts presented as to her personal history. She was a survivor of sexual assault as a child. She'd been in an abusive domestic relationship later on in life. She'd successfully overcome a drug addiction, completed her education, and she was a single mother. So she was really desperate, eager to provide for her son, and it was extremely important for her to keep up a well-paying job. And this is what played a role in her complying with the respondent's demands of her. Next slide, please. And these are all of the factors that the tribunal assessed in determining that really this was a case that where the award must fall at the highest end of the spectrum. Next slide, please. Yeah, next slide. Thank you. So the next decision, the third decision that I'm going to be discussing is on the basis of discrimination, namely due to race, versus the other two decisions that we took a look at. If we could go to the next slide, please. This is the decision of YZ and the Halifax Regional Municipality and the Nova Scotia Human Rights Commission. So this is a decision that was rendered in two parts. The liability determination was rendered in 2018, and the decision on the quantum was released by the Nova Scotia Human Rights Commission a little bit later in mid-2019. And in a later slide, you'll see the sum awarded was almost $600,000 to the applicant. And this is the highest award by the commission to date that has come out of Nova Scotia. So here, the complainant filed a complaint alleging discrimination. And what is interesting is that the discrimination complained of was on the basis of protected grounds of others. Whereas here the applicant himself was a Caucasian male, but he was alleging that he suffered discrimination on the basis of race, color, and the Aboriginal origin of persons with whom he associated. So the associates here were his work colleagues, whom he supported when they experienced discrimination in the workplace, as well as the protected grounds of his wife, who identified as being African Nova Scotian. Next slide, please. So here the tribunal or the commission states that on the basis of a previous decision, Meisner, the commission indicates that demonstrating that a person suffered discrimination on the basis of protected grounds of others is really quite, it's the same simple analysis. There's nothing more complicated than when we're analyzing the case based on the protected grounds that the complainant is alleging. So in the first place, the complainant must demonstrate having an association with someone that falls under a prohibited ground of discrimination. And secondly, the complainant has the burden of demonstrating that the conduct complained of was the result of that association. So in this particular case, YZ was asked to demonstrate that he'd suffered a burden from the allegedly poisoned work environment and the racial harassment because of his association with his wife and with his colleagues that were part of other minorities. And as per the Meisner case, the tribunal or the commission determined that complicating the analysis more than this would not be consistent with the remedial purposes of the act, and that those purposes are to be interpreted very liberally. Next slide, please. So here the complainant YZ was a Metro Transit bus garage worker since 1979, and between 2002 and 2007, he was the target of verbal racial slurs, graffiti, vandalism to his tools in the workplace, eventually assault, which actually involved the respondent using a bus to drive past him in a threatening way. The respondent in this case was a supervisor. He was the perpetrator of most of the wrongdoing. He was actually fired by the company in 2000 due to a racial incident involving another work colleague, but he was ultimately reinstated under the provisions of the collective agreement. So ultimately, in 2004, YZ said that the stressful environment led him to take a leave from the job. He ultimately returned a little bit later on light duties, but that was only for a period of about 6 months. He then left his job again in early 2007 on disability, and he'd been unable to go back to work or hold any other employment up until the time that the case came before the commission, which was over 10 years later. The wife also testified here and stated that she witnessed a change in him that started around 2000 or 2001. Her husband went from being her rock to a broken pebble. She testified that the two of them at the present time had no relationship, and her son said that his father had died 7 years ago. Next slide, please. So ultimately, when determining the amount of the damages to award to the complainant, the commission found that this case showed a particular depth of racial hatred that extended to the complainant because of his association with his wife and with Black or Indigenous colleagues. And in considering the appropriate range of the general damages, the commission was guided by several factors. The first one being to grant redress for the harm suffered by the discriminatory conduct, which in this case, the harm extended over economic, sociological, and emotional pain or problems, and really encompassed the entire family. The commission was also conscious of the need to ensure that a message is delivered to the complainant, to the respondents, and to others that human rights must be respected and protected. And another factor that was considered by the commission is the need to ensure that the award does not appear to be so small as to constitute a minor cost of doing business, which could encourage risk-taking. Next slide, please. So to look at a breakdown more concretely of the damages that were awarded, $105,000 in general damages to the complainant, and a large sum, the bulk of the award was $430,000 to the complainant for past and future lost income. Now, there was also a portion here that was granted to the complainant's wife in general damages, for the effect that these facts had on her and her relationship with her husband. In looking at the component that is the past and future loss of income here, there were a few relevant factors. And again, this is really what contributed to the size of the award. So the commission was looking at restoring, to the extent possible, the applicant into the position that he would have been in had the discrimination never occurred. The complainant must show, in circumstances where loss of income is compensated, the complainant must show a causal connection between the discriminatory act and the loss of income. And the amount of the compensation is a matter of discretion, ultimately, to be exercised in light of the purposes of the remedial provisions of the human rights legislation. So in this case, the aggravating factors that the commission took into account, which contributed to the award, were the fact that the discrimination had a real impact on the applicant's mental and his physical health, as well as his quality of life. There was a marked psychological impact that caused a loss of pleasurable activities and the amenities of life, which persisted for a period of 12 years up until the case came before the commission. The commission found that the odds of the applicant returning to any employment, even after 100 weeks of intensive treatment, were very low. And the applicant also underwent a change of personality that had a marked impact on his relationships. His health deteriorated, and a friend who also testified before the commission said that she had witnessed him become withdrawn, angry, depressed, and even suicidal. The next slide, please. And looking at more closely at the, next slide, please. Thank you. Looking at the award of $33,000 that was granted to the complainant's wife, these were some of the factors that the commission took into account in determining the appropriate award to compensate the wife as well for the harm suffered. So she was off of work for 2 years in particular in order to support her husband during the time that the hearing was taking place. That completes my presentation for today. Thank you very much. I will turn it over to my colleague, Nicole.
Thank you very much, Rhonda, and good afternoon, everyone. Just to quickly reintroduce myself, my name is Nicole Singh, and I am a senior associate in the Labor and Employment Group in the Toronto office at Fasken. So as part of our final kind of leg here in the presentation, we wanted to return to a topic that is one that we're all frankly very tired of, but one that is nonetheless still very relevant and important and will continue to be relevant and important as we move through this pandemic. And of course, that topic is COVID-19. Next slide, please. So what has the impact of COVID-19 been on the workplace? Next slide, please. Now, some of the images up on the screen right now might be very familiar to many of you as we work from home. And as some people have said, they're not sure if we're working from home or homing from work because we're doing all of that under one roof now. But these are some of the images that reflect the new reality of our lives of working and doing home all at the same time, kind of 24/7. Next slide, please. So this has been our reality. We keep calling it the new normal, but it's really been our reality since about March, when the economy shut down and we were all, for the most part, forced to work in our homes, much like we are today on this presentation. And what we found is that as employees are working from home, we also have situations for many folks where you're working from home, but you're also working at home with, you know, a spouse, a partner, or your children. As we saw earlier this year with schools closing and daycares closing, that meant that a lot of employees who have children were forced to have conflicting interests between their family and their work, which obviously created a lot of tension. And so where we see that arising at the workplace is having employees requesting accommodation on the basis of family status. Next slide, please. So what does that mean for employers? Well, if you haven't seen it already, what we anticipate you seeing is an increase in the number of requests that are being made for accommodation on the basis of family status. And as we all know, we're now in the second wave of the pandemic. We don't know what's going to happen. We know that the numbers are greater than they were before. And so the possibility of continuing shutdowns, of schools shutting down, only means that employees may very well need more accommodations as we move through this pandemic. Next slide, please. So for the latter part of this presentation, what we want to do is give you a refresher on what exactly is family status and what is family status accommodation. So next slide, please. So starting off, what is family status? Well, family status is a protected ground discrimination in every jurisdiction across Canada. So it's protected federally and within the provinces. Now, while it is protected in all of the provinces and federally, it isn't defined in all of the statutes. Next slide, please. So as I said, all human rights legislation protect family status. In Quebec, you'll see it called civil status. And they're all, family status or civil status is a ground of prohibited discrimination in the statutes. But like I said, family status is not necessarily defined in all of the statutes. Where it is defined, we see that family status includes a parent-child relationship. And that can take on different forms. So the most typical form that we see that arise in is a parent towards their child. However, another way that we see it, and probably the second most common way that we see family status accommodation requests come up in the workplace, is where it's a child towards their aging parent. A third way that we see parent-child relationship that does overlap with the first two that I mentioned is blood, marriage, and adoption ties. So what does that look like? That looks like stepchildren in relation to their step-parents or vice versa. It also looks like adoptive children in relation to their adoptive children or vice versa. Now, what we've seen is that the term family is also interpreted differently. So in some jurisdictions, we see family defined or interpreted quite narrowly. And in other jurisdictions, we see that family is defined quite broadly, very broad and encompasses different types of family structures. What we've seen in recent years, I would say within the last, well, in recent years, what we've seen is an increase or a broadening of the definition of family. So whereas we typically would have seen years ago family defined as a parent-child relationship between biological children and their parents, what we've seen is family being broadened to include other types of family. So foster children in relation to their foster parents, adoptive children in relation to parents, families headed by same-sex couples, families headed by a single parent, legal guardians, and even relationships involving cousins, grandparents, uncles, aunts, and in-laws. A lot of human rights commissions have said that the definition should actually be given even broader interpretation. And so when we look at what a broader interpretation would look like, things that have been considered are persons in analogous relationships to a parent-child or chosen family. And that would encompass things like strong friendships or communities. What will be interesting to see is while we're in this pandemic, if that influences the definition of family and family status. And so what I mean by that is, as we are taking on more responsibility and helping each other out, what we might find is that we're taking on responsibility for people and caring for people that are not in our immediate family, or that might not be previously understood as being part of family when looking at family status. So that's one of the things that as employers you want to watch out for. You may be getting requests for accommodation for people having to help family members that are not part of their immediate family, or who may not have been, within the traditional definition of family under family status accommodation. Next slide, please. So of course, the question that is of prime concern for employers is, what are your obligations with respect to family status, and in particular right now with the pandemic? Next slide, please. So I won't go over the test, but essentially, in order to understand what your obligations are, it is very helpful to understand how an adjudicator assesses family status discrimination and family status accommodation. So I won't go over the test. My colleague Dave did go over the test for discrimination earlier when talking about one of the decisions he discussed, but essentially, when looking at the test for discrimination, it's a two-part test, and the employee has to first show that there's a prima facie case of discrimination. So just very briefly, again, that means that they have a characteristic that is protected under human rights legislation. They've experienced adverse treatment, and the adverse treatment, there's a nexus between the adverse treatment and their characteristic protected by human rights legislation. If that's established, there is what we call a prima facie case of discrimination, and then the burden shifts over to the employer to either disprove that discrimination or to show that it's justified, either because it's protected or there's a justification under statute, or because there's a bona fide occupational requirement that makes it basically impossible, undue hardship to accommodate this employee. Next slide, please. So although that is the neat and very well accepted test for discrimination, when we look at discrimination applied to family status, what we see is that the test is varied. So I won't go through the facts of all of these different cases that are up on the screen there, but I will just go over the test. So Campbell River is a decision out of BC, and the leading decision there basically says that the test for discrimination based on family status is that there must be a change in a term or condition of employment imposed by the employer, and the results, that change must result in a serious interference with a substantial parent or other family duty or obligation. In the federal jurisdiction, we have the Johnstone decision, and actually that is followed in many jurisdictions. And the test there is that the child is under the care and supervision of an employee. The child care obligation engages the employee's legal responsibilities for the child as opposed to a personal choice. So the distinction there being a legal responsibility, when you think about a very young child, you cannot leave a very young child at home. So if an employee has to be at home to care for their child, that would be a legal responsibility versus an older child, say a teenager who may be ill and has to be at home. That might not be a legal responsibility. It might be a preference that you want to be home with your child. So the contrast there between legal responsibility and a preference. The third step of the test is the employee has made reasonable efforts to meet their childcare obligations, but notwithstanding those efforts, no reasonable accommodation or alternative solution could be found. And the fourth step is the workplace rule interferes in a manner that is more than trivial or insubstantial with the fulfillment of the childcare obligation. Next slide, please. And just to add to the, again, variety of tests that have been applied in the family status area, we have an Alberta decision, SMS equipment, and there the test is the child is under the individual's care and supervision, and the child care obligations at issue engages the individual's legal responsibility for the child. And then in Ontario, we have MySec, which says the test is more than a negative impact on a family need is required. The negative treatment must result in a real disadvantage to either the responsibilities that flow from the family relationship or the employee's work. The second step is the negative impact is assessed contextually and may include consideration of other supports available to the employee. And thirdly, the existence of a legal obligation is not required. The reason for that is it's harder to show a legal obligation when you're looking at the relationship between a child and an elder parent. It's easier to establish that relationship or that legal obligation when you're looking at a parent towards a child. Next slide, please. So when you're accommodating or when you get an accommodation request as an employer, it's good to have that case law in the back of your mind to understand not only how you should be looking at it, but frankly, if things don't go well, how an adjudicator will be looking at it. So what are an employee's duties? Well, typically, the duty to accommodate usually arises because an employee brings forward a request for an accommodation. Once that's done, the employee should be providing all of the information necessary in order for the employer to properly understand how the employee's family status affects the job performance and what accommodations may be needed and may be appropriate. The employee will also need to provide information demonstrating that, again, the caregiver responsibility is a need rather than just simply a preference. Importantly, the employee also must cooperate in the accommodation process. And again, importantly, the employee must actually accept reasonable accommodation proposals. So even if it's not perfect, it's not maybe their most desired accommodation, if it's reasonable, the employee does have an obligation to accept it. On the employer side of the duty to accommodate, it's a twofold obligation. So the first is a procedural component, and that basically means that the employer, again, has to obtain all of the relevant information in order for them to properly assess the employee's family needs and consider the steps that the employer may need to take in order to accommodate the employee. The second step of the employer's duty to accommodate is a substantive component. And so there, the employer has to show, or has to offer rather, reasonable accommodation to the employee, or alternatively be able to explain why they cannot accommodate the employee because they would experience undue hardship. Next slide, please. So what are the possible accommodations during COVID? Next slide, please. So in terms of what you can do to accommodate employees right now through COVID, some of them look much the same as what you would have done before, and some of them are a little bit different. So the first one, which most of you, your employers are probably already doing, is instituting work from home policies. Now, pre-COVID, work from home policies were definitely not the norm, and for most employers, they would prefer to have their employees come into the workplace. It's important that during COVID, you have flexibility and a little bit more tolerance for things that you may not have really loved before, or would have been kind of preferable before the pandemic. Where your employees are able to work from home, even if it's not the desired way for them to work, if that's a possibility and reasonable to happen, you should be allowing employees to work from home. Creating modified and flexible work schedules will also be very important. One thing that I think adjudicators will take into consideration if they are deciding on an accommodation case during COVID is how flexible was the employer. I do think that adjudicators are going to expect employers to exercise a little bit more tolerance and flexibility during the pandemic. In addition to the statutory leaves that are available to employees, some of which have been implemented specifically for COVID, employers should also consider whether there's the option of providing employees with paid leaves during the pandemic. You also want to consider modifying employees' duties and responsibilities as needed. So some employees may be able to continue working, but may not be able to either work as many hours or may not be able to take on as many responsibilities given any conflicting family obligations. So that's one thing that you can also consider as a possible solution. Finally, you'll want to consider implementing accommodation policies. If you already have such policies, now is the time to update them to reflect the novelty of the pandemic and possible accommodations that your employer is offering. The key is remembering to be flexible in your approach. And again, I do think that where things go sideways and it results in a complaint, I do think adjudicators are going to have a higher or place a higher emphasis on employers being more tolerant and flexible during this period of time. Next slide, please. So in terms of what are the best practices, again, some of these apply pre-COVID, but some of them are things that you'll need to start thinking about during COVID. Next slide, please. So again, updating all relevant policies to ensure that they reflect any accommodations that are currently available to your employees. You want to make sure that those policies are easily accessible so that employees can easily obtain them and find out what accommodations are available. Consider alternative work options. Be aware of, again, applicable statutory leaves. Make sure that you request all the information so that you can get to the next point, which is 5, deciding whether family status is engaged. You won't be able to do that unless you have all the information in front of you. 6 is determining if accommodation is possible without undue hardship. And again, the threshold for undue hardship is very high. So you want to make sure that you're doing a proper analysis to make sure that you are seriously considering whether accommodations can be made. And 7, you want to make sure that you document everything. Some of these changes will vary the terms of employment of the employee, and so you want to make sure that they're well documented, whatever changes were made. Next slide, please. Now I'm noticing time and I want to make sure that we do leave enough time for questions. So I'm very quickly just going to go over some of the potential liability if you are not accommodating employees through the pandemic. Next slide, please. And actually next slide over. So of course, the potential liability can be great when you're thinking about the monetary sanctions. So in terms of monetary sanctions, employees can be compensated for lost wages and benefits that they experience as a result of not being accommodated. They can experience, they can be compensated for humiliation and loss of dignity and mental anguish. Now, the range of monetary sanctions can be great. As you've heard my colleagues say, we're seeing increase in damages being awarded for different things like sexual harassment, racism in the workplace, and family status is no different. While in Ontario, for example, we've seen extraordinary cases for family status violations being $30,000, it is quite possible that that violations could warrant greater monetary sanctions, particularly during COVID, where we have unique circumstances. Non-monetary sanctions can include training and the development of policies for the employer to implement in order to rectify any family status accommodation issues. And then of course, third but not least is the reputational harm that you can suffer as an employer if you don't take family status accommodations seriously. Now I am noticing the time. Unfortunately, we don't have very much time left, so I think I'm going to stop there so we can turn over to any questions.
Great, thank you, Sarah, Rhonda, and Nicole. Just very briefly on family status, on what Nicole said there. If you are in BC, things continue to evolve on the family status front, as you probably have seen over the years. Right now, the tribunal has only last week, I believe it was, issued another decision relating to it and taking the position that there doesn't need to be a change to the terms and conditions of employment. Only a change relating to a substantial parental obligation. So we'll see where things go, just as a heads up. Very quickly, and we don't want to keep you any longer than the time you've already given to us. I'm going to get to just a couple quick questions. For Sarah Graves on sexual harassment, what are our legal obligations to terminate employees engaging in virtual workplace harassment where other factors exist, i.e. mental health concerns, domestic violence, etc.?
That is a really great question and a very timely question that a lot of people, unfortunately, are dealing with at this point. I mean, I think you start from first principles. So you look at what the virtual harassment actually is. If you've got someone who is directly harassing someone on a Slack chat, for example, then you would treat that the same way that you would other virtual, like other harassment in the workplace. If you found someone was doing that on Facebook, for example, or on their work email account. Always when we're evaluating these situations, we do consider, aggravating and mitigating factors. There aren't decisions where we can say that definitely the pandemic will be seen as a mitigating factor But issues like mental illness issues may suggest accommodation if, for example, there's a direct link between the harassing behavior and a mental illness, for example. Beyond looking at, is it direct harassment, some of the issues we're finding are sort of these accidental exposures of otherwise inappropriate behavior. So it's really a matter of unpacking the harassment. So in some of the examples I gave, for example, there was an underlying inappropriate exchange between employees that was then publicized accidentally. In another instance, we've got someone, watching porn when they should be attending a meeting. That's another type of misconduct that you would need to consider when you're doing an investigation. So generally, my advice would be treat these instances and unpack them the way you would a typical, sexual harassment case, but then, speak to your legal advisors about some of the specific mitigating and aggravating factors that may impact a particular situation.
Great, thank you, Sarah. I see we're very close to the end here. I'd just answer a very quick question on EDI and special programs about collection of diversity data from existing employees. Is there a way to collect this data without the risks mentioned, or is it only allowed as part of special programs? You can collect that as long as you have consent from the employees. It's what you do with it as to whether you'd need to get approval or whether it might fall within a special program that you'd have to consider. I see, unfortunately, we're out of time, and if we did have a couple more questions that we were hoping to get to, but given the time and in the interest of being appreciative of all the time that you've already spent with us, I think we're going to wrap it up there. If you do have questions you'd like to follow up with us about, please feel free to reach out. We'd be happy to answer them. Again, I just want to remind you, if you could please fill out the survey at the bottom of the screen, we'd really appreciate that. And of course, we've got the 2020 Year in Review series coming up, the other 3 sessions that we'd love to have you join us for. Thank you very much again for your time. Very much appreciated.